To Dr. Deputy Gino Kenny.
Thanks, Chair. I think we've ascertained that there are variations in a lot of countries around assisted dying where it's been legislated for. And a number of countries, probably over 20 countries in the world, have assisted dying in some format. I just want to state that my own personal opinion, somebody of advanced age, somebody with a disability, or somebody on mental health grounds should not be able to avail of assisted dying. That's my own opinion. There is other people that have different opinions to that, but that's my own opinion. So that kind of gives a framework. The framework that I would look towards is Oregon and New Zealand. New Zealand obviously legislated a number of years ago. And obviously in circumstances where something was illegal, then it becomes legal. Obviously people will avail of it. And you can apply that to a lot of things in the world. I think that's perfectly understandable. So where there's variations and where there's frameworks and where there's safeguards, people as a choice should still be able to avail of that choice. Now, I know you're going to disagree with that, right? And that's your prerogative. And Professor Ewell, that's his prerogative as well. And I think John has kind of hit on it very, very well in regards to those that are in them circumstances. Because we have a paternalistic view of somebody in society that, you know, doctor knows best, society knows best, but try to walk in my shoes in certain circumstances where they're coming to the end of their life and they should have a say. Again, it's a fundamental right of any human being to say, look, I do not want to go through certain weeks or months or days of my life. It's my life at the end of the day, not yours and nobody else's. So somebody should have a say. They can refuse medical treatment, they can refuse food or water, you know, that's their perfect right. But why should they be stopped and saying, look, I don't want to go through a very painful end to my life?
You spoke very articulately about the reasons on behalf of your particular proposal. You mentioned paternalism, the idea that unless you can walk in someone's shoes, you can't see what they're going through, the idea that euthanasia access is a fundamental right, and the idea that it's that person's life and it's not yours. I think all of those are, you know, they count as the core of the rationale for euthanasia access. But each of those can be turned against your own proposed restriction of euthanasia to cases of terminal illness, that you're failing to be seeing that others have a fundamental right, that it's their life, that you haven't walked in their shoes, and that you're being paternalistic. And I suppose what I'm trying to get at is, when we see what the rationale means in principle and centrally, and where it's oriented to go as a matter of reason, then it becomes less attractive, much less attractive than we might initially think, and much more problematic in terms of respecting key goods that we take for granted in healthcare. It was also mentioned about Oregon being a good model. There's a good paper forthcoming in the Journal of Supportive and Palliative Care called Oregon Death with Dignity Access 25-Year Analysis. Talks about a number of things. One of the things it highlights is that all reporting from Oregon is self-reporting. So something you might want to bring up later on. I think you have a different later session. And even then, as I try to make clear in my written submission, there is expansion going on in Oregon beyond terminal illness, into chronic illness, badly misprognosed cases, and also, importantly, an admission from the Oregon Health Authority that, and this is I think relevant to Dr. O'Donovan's thesis, that someone who has a non-terminal illness but who refuses treatment for that illness, thereby translating that chronic illness now into a terminal illness, won't be refused access to Oregon's assisted suicide provision. In other words, a law which tries to be structured around terminal illness cannot insist that the person go through treatment of a chronic illness or any illness. And that means that what was a non-terminal illness thereby becomes terminal because of that refusal to treat. And that's relevant to Oregon. It's also relevant here because it's a constitutional right here that one has a right to refuse medical treatment. And indeed, the restriction that one, exhaust all avenues of respite, which Dr. O'Donovan advocates, is not one that's present in any jurisdiction that I'm aware of anywhere in the world. I don't think it could be, because it runs badly against a core rationale for euthanasia, which is autonomy.